Welcome back, my friends. The news today is that Twitter violated contract by failing to pay millions in bonuses, U.S. judge rules. On December 23, 2023, a U.S. federal court ruled that Twitter, now known as X, violated contracts by failing to pay annual performance bonuses. The former employer, Mark Schobinger, filed the lawsuit in June 2023. The court's decision was based on the following. Schobinger's claim of breach of contract under California law was valid. Twitter's offer to pay Schobinger a bonus became a binding contract once Schobinger did what Twitter asked. Twitter promised employees 50% of their 2022 target bonuses, but failed to follow through. Current and former Twitter employees have also said they never received bonuses they were promised. But before we get into all of that, please hit the like button and leave us a comment below. We would love to hear from you. Please subscribe and hit the bell icon so that you are notified of upcoming videos when they are released. And before we continue, a word from the sponsor of this video. Today's sponsor is ProWorldNet.com. ProWorldNet.com is a job website specifically dedicated to licensed professions. Doctors, including any type of specialty. Nurses, and that includes all grades of nurses. Lawyers, regardless of area of legal focus. Teachers and professors, from kindergarten through graduate school, as well as any kind of job that requires a government license or certification. And ProWorldNet.com also includes short-term gig-type jobs as well. So be sure to check out ProWorldNet.com if you are looking for a job or an employee. A federal judge ruled late Friday afternoon that Twitter, now known as X, violated a contract when it failed to pay what amounts to tens of millions of dollars in bonuses that the company had orally promised its employees. Twitter violated contracts by failing to pay millions of dollars in bonuses that the social media company, now called X Corp, had promised its employees, a federal judge ruled on Friday. Mark Schobinger, who was Twitter's senior director of compensation before leaving Elon Musk's company in May, sued Twitter in June, claiming breach of contract. Schobinger's suit alleged that before and after billionaire Musk bought Twitter last year, it promised employees 50% of their 2022 target bonuses, but never made those payments. In denying Twitter's motion to dismiss the case, U.S. District Judge Vince Cabrera ruled that Schobinger plausibly stated a breach of contract claim under California law, and he was covered by a bonus plan. Once Schobinger did what Twitter asked, Twitter's offer to pay him a bonus in return became a binding contract under California law, and by allegedly refusing to pay Schobinger his promised bonus, Twitter violated that contract, the judge wrote. X no longer has a media relations office. The company did not immediately respond to a request for comment to its X account outside business hours. Twitter's lawyers argued that the company made only an oral promise that was not a contract, and that Texas law should govern the case, according to Courthouse News, which first reported the ruling. The judge ruled that California law governed the case, and that Twitter's contrary arguments all fail. X has been hit with numerous lawsuits by former employees and executives since Musk bought the company and culled more than half of its workforce. The lawsuits make a range of claims, including that X discriminated against older employees, women and workers with disabilities, and failed to give advance notice of mass layoffs. The company denies wrongdoing. Mark Schobinger, the former senior director of compensation for Twitter, filed suit against the social media company on behalf of himself and other current and former Twitter employees in June. Schobinger, who is based in Texas, claims that employees were not paid a portion of their 2022 bonuses when they were due in the first quarter of 2023. Despite repeated promises from senior executives at the company, including Ned Siegel, the former chief financial officer of the company. This bonus was to be paid to employees who stayed with the company until the first quarter of 2023. According to Schobinger, these promises were made both before and after Elon Musk acquired the social media platform in October 2022. Schobinger also said employees took these promises into consideration when deciding whether or not they wanted to leave their jobs with the social media company, and that he turned down opportunities from other companies at the time because of the promised bonus. Twitter's lawyers argued that the promise was only an oral promise and was not a contract, and that Texas law should govern under Section 1646 of the California Civil Code, which states that a contract is to be interpreted according to the law and usage of the place where it is to be performed. U.S. District Judge Vincent Cabrera, in a brisk 3-page opinion, wrote that California law governs the case because the choice of law provision in the California Civil Code applies only to matters of contract interpretation, not to matters of contract validity or enforceability. Because Twitter doesn't even try to argue that Texas law should apply under the governmental interest approach, California law governs by default. Chabria said that Schobinger plausibly stated a breach of contract claim under California law, and that Schobinger was covered by the bonus plan and followed all of Twitter's directions. Once Schobinger did what Twitter asked, Twitter's offer to pay him a bonus in return became a binding contract under California law. And by allegedly refusing to pay Schobinger his promised bonus, Twitter violated that contract, Chabria wrote. Shannon Liss Reardon, counsel for Schobinger, said in a statement to Courthouse News that, "We are very pleased with this decision. This is a very important decision which is relevant to claims we have filed on behalf of nearly 2,000 Twitter employees." The court agreed with our argument that later promises, even oral promises, can be binding, even if the original written agreement is not enforceable. In this case, we allege that promises were made to ongoing Twitter employees who stayed with the company through Elon Musk's tumultuous acquisition that they would receive a bonus for 2022. Chabria wrote that Twitter's contrary arguments all fail. Twitter argued that the performance bonus plan was not an enforceable contract because it provided only for a discretionary bonus. But Schobinger is not suing to enforce Twitter's discretionary bonus plan. He is suing to enforce Twitter's alleged subsequent oral promise that employees would in fact receive a percentage of the annual bonus contemplated by the plan if they stayed with the company, Chabria wrote. The social media platform also insisted that the oral statements were not enforceable because they contradict the terms of the performance bonus plan and do not satisfy California's special rules for oral modification of written contracts. But those rules come into play only when a valid, enforceable written contract already exists. And as Twitter itself argues, its discretionary bonus plan was never a valid, enforceable contract to begin with, Chabria wrote. Schobinger's primary estoppel claim, however, was reluctantly dismissed with leave to amend because the plaintiff still needs to take the seemingly pointless extra step of pleading that the alleged contract may be invalid or unenforceable, Chabria wrote. Schobinger can file an amended complaint within 21 days to address his primary estoppel claim. But what do you think? Please hit the like button and leave us a comment below. We would love to hear from you. Please subscribe and hit the bell icon so that you are notified of upcoming videos when they are released. Please share this video on social media. Thank you for watching.